Hello and welcome to Agenda on NDTV 24/7. I'm Kajari Sen, and today the Supreme Court recriminalized homosexuality by putting aside the Delhi High Court's verdict from 2009, which stresses that Section 377 impinges on the fundamental rights to life and liberty. The Supreme Court's decision has thrown up many questions. Today, we only have time to touch upon two key points. Firstly, was the Supreme Court within its rights to privilege a section of the penal code over a fundamental right? Secondly, what does this mean for the LGBT movement that had gathered so much momentum over the last 4 years? Will it be forced back underground? We have our guests with us. First of all, to get a sense of whether homosexuality is legally wrong or morally right, we've got both sides of the debate represented. Lawyers Majid Memon and Colin Gonsalves with us. And also to talk about whether it's too late to closet the LGBT movement, we've got Ashok Rao Kavi and Gautam Bahan, LGBT activists, who are with us. But before we go over to our guests, let's first take a look at what the Supreme Court did today.
I wasn't a criminal yesterday, but I'm certainly a criminal today. Oh, and I may as well say on your channel that I propose to continue to be a criminal.
It's a huge setback.
This is an unconstitutional judgment.
Affects your morale as to who you are, and do you have the confidence to come out and be who you are?
At the end of the day, I think every human being has a right to live their life the way they want to live it.
Shock, disbelief and heartbreak across the country as the gay community, rights activists and even some legal experts questioned the Supreme Court when it set aside the 2009 landmark judgment of the Delhi High Court, which had decriminalized homosexuality. Today, the Supreme Court reversed the order, which means gay sex, even between consenting adults, will continue to be a criminal offence that can invite a life in jail. The court has ruled that the Delhi High Court verdict is constitutionally unsustainable and there is no constitutional infirmity in Section 377, and that it is now up to the government to take appropriate legislative steps to scrap 377. Those who have waged a long and difficult legal battle seeking equal rights for the gay community say the Supreme Court verdict has set them back by decades, while others did not agree with the court lobbing the ball into the government's court.
They have not deferred to Parliament over the last 5 years, which is why I would throw back the question, why only when it comes to human rights do they defer to Parliament?
If a Supreme Court's position is that it is not the correct recipient of a question of constitutionality of statute, to whom else am I meant to address this question?
For those who had petitioned against the Delhi High Court order, it was a welcome decision.
Legally, this means that there is no fundamental right in sexuality as far as I feel. And what the Supreme Court says that no fundamental right has been violated. What they're talking about, they have set aside the High Court judgment.
Legally, the way ahead for the LGBT community is to file a review petition, and if that too is turned down, the last option would be a curative petition.
The LGBT community says they're heartbroken but not ready to give up. They say they'll file a review petition in the Supreme Court, take their fight to the streets and try and build pressure on the government. But having done a series of flip-flops on the issue and now being described as a lame duck government, will the centre have the political will to legislate on such a sensitive issue? With Siddharth Pandey in New Delhi, Neha Khanna for NDTV.
And furious responses coming in from across the country, not just the big cities, but also the smaller towns.
ये बताइए कि कोर्ट का ये आदेश आया है, आप लोग इसके किस तरीके से खिलाफ हैं और आप लोग क्या चाहते हैं कि ये अधिकार जो है फिर से वापस लोगों को दिया जाए?
मैं कुछ चाहती हूँ ये कि उन लोगों को अपना खुद जीने का अधिकार है, वो लोग भी अपनी तरीके से जीना चाहते हैं और उनका ये अधिकार उनको ज़रूर मिले कि वो आगे बढ़ें और वो अपनी लाइफ को अपनी तरीके से सेटलमेंट करें।
क्यों ज़रूरी है इसके खिलाफ आवाज़ उठाना आपके लिए? क्योंकि आप लोग तमाम लोगों से डील करते हैं, वो आपके पास अपनी समस्याओं को लेके आती हैं, तो समलैंगिकता के लिए आवाज़ उठाना क्यों ज़रूरी है आपके लिए?
हमें लगता है कि मानव अधिकार का हनन है ये, और जिस तरह से ये जजमेंट आया है वो अगर हम संविधान को देखें तो उसके आधार पे बहुत ही गलत है। अगर स्वतंत्रता का अधिकार है तो ये हमारे मानवाधिकार का हनन है।
Lucknow traditionally has had a history of lots of persecution of the LGBT community, and there have been cases where in a sense people have been wrongfully arrested for this particular crime when it was actually a crime, and now is once again a crime in the books. How come Lucknow is a place which also has to come out and voice its dissent with this judgment? Because we've seen a history of persecution by the police as far as the community is concerned.
Yeah, but it's not this is not the only community which has been persecuted in Lucknow. And you know, the whole battle in fact started out coming out openly began in Lucknow when the people, our friends from NAS Foundation, were arrested. And we believe strongly, not only as a women's organization, but the groups and individuals who are working for the human rights, that this is absolutely a violation of our constitutional right and right to life.
That lady there, in fact, asking the question that I'm starting this conversation off with. Let's go over to our guests to ask them, has the Supreme Court chosen to favor a section of the penal code over a fundamental right? Mr. Gonsalves, to you first.
Well, I must say we are totally dismayed, aghast at this judgment. The High Court judgment was such a beautifully written constitutional law judgment in keeping with international principles and the Indian Constitution. And now we have a judgment which takes us 200 years back into the dark ages where we will persecute and harass, you know, the minority community. I was totally dismayed. I can't understand how the court can possibly do this kind of thing.
Right.
And millions of young people, not just sexuality minorities, let me tell you, millions of young people who have totally different sexual mores. I mean, it's a changing society. India is a young society with young people doing things by consent which perhaps 100 years ago would have been stigmatized. And I think the Supreme Court has distanced itself from young people. It has lost credibility in the eyes of young people that consensual sexual activity should never be criminalized in this matter.
Right. Mr. Menon, I believe, Mr. Menon, you feel that the Supreme Court was well within its rights to do what it did.
See, there are two reasons why I am saying so, Kajori. I appreciate that, you know, soon after the pronouncement of this verdict, there has been a lot of noise throughout. We have seen all the television channels and everybody, there is a expression of anger, dismay, and just now we have heard Mr. Gonsalves also taking that view. But let me, explain why I am saying so. You see, please don't rush to conclude that the Supreme Court has taken us 100 years backward, etc., etc. If you look at Section 377 as it stood till 2009, when the High Court set it aside, High Court removed this. Now, it says against unnatural offences. Offence, you see, against the order of nature. That is what the legislative expression is. Now, I am not saying that, well, that should be done. What is important is that the laws are made to meet the needs of the society from time to time. If today the society believes that, well, let us permit A activity or B activity, and if the majority is happy with that, then probably the lawmakers will have to consider that and then decide accordingly. And Supreme Court has rightly said that it is for the Parliament to examine, Parliament to examine what is the need of the society, what would be good for the society in 2013 or hereafter, and accordingly enact law. In fact, Supreme Court should do it in cases of all social, any social policies, any moral policies, any economic policies. The laws are not made by courts. The laws are only interpreted by court, and His Lordship Justice Singhvi on the parting day today has said the same thing which he should have said even earlier.
Well,
there is a criticism that why for the past 5 years they are not asking Parliament to enact law. They must ask, it's right.
Saying that the court upheld the law as it existed in the books. Let's go over to Ashok Rao Kavi, who clearly wants to take count to that point.
I just wanted to point out some sort of fallacies here. This law was brought by the British, by the colonial authorities, not by constituted parliamentary democratic forces in India, which if he says that they determine the laws, the people are supposed to give laws to themselves. This law is not that way. Right. It was brought in by the British. It was imposed during the colonial times. The law as it stands has been retrieved, or it has been taken off the statute books in England itself. So what he says that the people or the parliament has a right to make this law. I give him that, I concede it. But this is not by parliament. This was a law brought in by colonial elements. Secondly, I want to tell you that I'm just shocked that it took 21 months for the Supreme Court judges to hear all the petitions and to give a 25-page judgment that just throws it back and says, let Parliament do it. I'm just amazed at the frugality of reasoning here. And I'm also shocked at the fact that they can just take away dignity from a segment of society which has been fighting it totally non-violently through the court.
Now let me just go over to Gautam here. Gautam, you know, all the points that Ashok Rao Kavi is talking about there, you've seen the judgment. How does the judgment stress upon those points?
I mean, let me make two very simple points. I've just looked at the judgment, and there's 2 points that I think we have to take very respectful but very strong disagreement with. One, the judgment claims that we did not, it said we failed miserably to prove that gay people in this country are harassed, blackmailed, tortured in police stations, and made to undergo rights violations on a routine basis in this country. As a petitioner in this case, I can tell you that we filed affidavit after affidavit to show stories of people given 2 years of electroshock therapy in aims to cure them of their sexuality, to find people who were forced into marriages, to find people who were gang raped in police stations, to find people who were blackmailed. I can count out these affidavits to you. And the argument in the judgment that we have not made a case of harassment is patently untrue. No one who knows anything about this country should need to be convinced that LGBT people are routinely have to fight lives of harassment and everything. The second argument that I really take on and take exception to, in paragraph 43 of this judgment, the justice says that a minuscule fraction of this country's population is lesbian, gay, bisexual and transgendered. I have 2 contentions. How minuscule is minuscule? 1% of India's population is 12 million people. How many does he need? And my second question is, at what point in our legislative history did we start weighing the question of rights by the quantum of the minority at stake? How many of us need to undergo rights violations for it to be enough?